Good afternoon to all. I would first like to thank members of the media for accepting the invitation to attend and cover this virtual media conference. I would also like to say good afternoon to everyone who um, who are listening to this program at this time and who would be listening on the replay of this program. This media conference is being carried live on Power 1021 FM and would be replayed tomorrow at 9 a.m. on Power 1021 FM, 195.5 FM, Akashvani 106.5 FM, and Sangeet 106.1 FM. So those who are listening to the broadcast, good day to you also in advance. As Trinidad and Tobago would know, I represented ANB in the dispute between ANB Oil and Gas Limited, ANB, hereinafter called ANB, and Petrotrin Company of Trinidad and Tobago Limited, hereinafter called Petrotrin, in respect of the termination by Petrotrin of the contract which ANB had with Petrotrin for ANB to explore and extract crude oil from Catskill Field in Barrackpore, and for it to supply and sell that oil to Petrotrin. That dispute led to a hearing before a panel of arbitrators for the determination of the dispute. The dispute was determined by the arbitrators and ANB was vindicated. The other members of the legal team who appeared for ANB consisted of Queen's Counsel Mr. Peter Knox of England, Mr. Ronnie Bissessa, attorney at law of the firm of Lawgivers of Trinidad and Tobago, Mr. Robert Strang, barrister at law of the United Kingdom, Mr. John Almeida, who is a solicitor of the United Kingdom, and Mr. Varin Gopal Gosain, attorney at law of the firm of Lawgivers. Present this afternoon with me are Mr. Ronnie Bissessa and Mr. Varin Gopal Gosain. I also have present this afternoon Mr. Hanish Baksh, who is the owner of ANB Oil and Gas Limited. I have called this media conference because I am of the opinion that the facts and circumstances which led to this arbitration are important for members of the public to recall, because those facts and circumstances would show that politics influenced the investigations which were conducted by Petrotrin against ANB, and which investigation led to Petrotrin terminating the contract with ANB. I say that politics influenced the investigation because the facts show conclusively that the investigation which was conducted by Petrotrin was triggered by statements made by the leader of the opposition at one of the public political meetings of the UNC in September 2017. At that meeting, she made serious allegations of fraud and misconduct against ANB and its owner, Mr. Hanish Baksh. And she linked those allegations to the Prime Minister of Trinidad and Tobago. Those allegations were that ANB was being paid by Petrotrin for the supply of fake oil, that is the overstated production of oil, that ANB was supplying a smaller quantity of oil but was getting paid for more oil, and that ANB was getting away with that fraud and misconduct because ANB and its owner, Mr. Hanish Baksh, were P&M financiers, and Mr. Baksh was a close friend of the Prime Minister. Petrotrin at that time had a newly appointed chairman, Mr. Wilfred Espinet, and the leader of the opposition called upon him and Petrotrin to conduct an investigation into these serious allegations which he was making against ANB Oil and Gas and the Prime Minister. 2 days after those allegations were made by the leader of the opposition, Mr. Wilfred Espinet, chairman of Petrotrin, made public statements which implicitly supported the allegations made against ANB by the leader of the opposition. Petrotrin thereafter embarked upon an investigation into the allegations. In conducting those allegations, however, Petrotrin refused continuously the request made by ANV for Petrotrin to consult with ANV and its legal team in order for ANV to give answers to all of the allegations made by the leader of the opposition. ANV contended in its letters to Petrotrin and in the media conferences which I held that the allegations made by the leader of the opposition were not true. The leader of the opposition based the statement she made about ANV and the Prime Minister on a preliminary document marked private and confidential. It was a preliminary internal report of Petrotrin. That report was not a final report. It was not even signed by the two auditors, alleged auditors. It was therefore not a complete report. It was signed by one of the alleged auditors. ANV also did not have any opportunity to comment on any of the allegations or statements made in that report. So that document, on the face of it, was shown to be private and confidential and was not a complete and final report. At the media conferences which I held and the letters which were written to Petrotrin, ANV took the position that the allegations made by the leader of the opposition and contained in that internal document upon which she relied were totally incorrect. ANV requested Petrotrin to state to it any particulars of the allegations it wanted ANV to answer, and that ANV was prepared to answer those allegations, and for Petrotrin to hold consultations with ANV, for ANV to convince and confront Petrotrin that the allegations were untrue. Petrotrin, however, took the position that it would give ANV a hearing and hold consultation at the right time. Petrotrin, however, never did that. It conducted a one-sided investigation in breach of every existing rules of procedural fairness and natural justice. Petrotrin retained foreign experts, Kroll Consulting Canada and Kaffney Klein and Associates, but it refused to permit those experts to consult with ANV in respect of the allegations, so that ANV would have been able to give to those experts whatever answers or explanations they wanted in answer to any of the allegations. Petrotrin also took the position that although it intended to rely on the reports of Kroll and Kaffney Klein, that those reports were private and confidential and were therefore not for the eyes of ANV and its lawyers. It was only for the eyes of Petrotrin. Petrotrin made it clear in its public statements and letters to ANV that it intended to rely on the Kroll and Kaffney Klein reports, but ANV could not see those reports to answer the allegations of findings because they were private and confidential to Petrotrin. In the media conferences I held, I informed the public of all of these matters. I told the public, I told members of the public that the newly appointed chairman of Petrotrin implicitly supported these allegations, and Petrotrin commenced investigations against ANV. In other words, Petrotrin accepted the call of the leader of the opposition. I informed the public at these press conferences that I and the legal team of ANV have reviewed the allegations made against ANV. We have looked at the evidence provided to us by ANV, and we have looked at the allegations made by the leader of the opposition and the internal audit report. And that I and the legal team were totally convinced that the allegations made against ANV were totally false. I made several requests of Petrotrin to hold consultations with ANV, so that we would be able to convince Petrotrin that it was going in the wrong direction. We told Petrotrin that we could give response to any queries it had in respect of any of the matters relating to the supply by ANV of crude oil to Petrotrin. Petrotrin did not make any request for any information until a few days before it terminated the contract. And Petrotrin did not accede or request for it to hold consultation with us. In my media conferences, I also warned Petrotrin publicly that if it terminated the contract with ANV, that action of Petrotrin would cause the taxpayers of Trinidad and Tobago millions of dollars to pay for the expenses which would be incurred by Petrotrin in such a legal battle, and for Petrotrin to also pay the expenses and fees which ANV would have incurred in fighting such a battle. I also told the country that that is separate and apart from what a tribunal may order in respect of damages for wrongful termination of the contract, if the contract was terminated. I told the country that we were totally confident that if Petrotrin wanted to go the route of an arbitration by terminating the contract, ANV would be vindicated. Petrotrin did not listen. Petrotrin decided that it would terminate the contract. It stated in a letter to ANV that based on the Kroll and Gaffney Klein report, it was of the opinion that ANV misconducted itself, but that it was giving ANV 7 days to respond to 13 issues, which it stated it wanted at the end of 7 days. Petrotrin was therefore telling ANV, Petrotrin thinks you are guilty. It has found you are guilty based on the reports of Gaffney Klein and Kroll, but Petrotrin is still giving you 7 days to respond to these 13 issues. ANV did its best in those 7 days to respond to all the issues, obviously handicapped by time. Petrotrin therefore had made up its mind to terminate the contract without properly considering the representations and the evidence of ANV. After ANV provided the answers to the 13 issues, best it could have done it in the 7 days, Petrotrin decided to terminate the contract. That was an overview of this matter. And with that introduction in mind, I would now trace with you the history of this matter leading to the arbitration. The claim before the arbitrators were for damages for wrongful termination by Petrotrin of the contract which Petrotrin entered into with ANV for ANV to explore, extract, supply, and sell crude oil to Petrotrin from the Cat's Hill field. The written contract between Petrotrin and ANV provided that in the event that there was a dispute between the parties, they first had to try to resolve the dispute by mediation. And if mediation failed, the dispute was to be resolved by a panel of 3 arbitrators. The contract gave the right to Petrotrin and to ANV to each appoint 1 arbitrator, and for the 3rd arbitrator to be appointed by the agreement of both ANV and Petrotrin. Petrotrin, after it terminated the contract, the dispute arose, and therefore it had to be determined after mediation failed by a panel of 3 arbitrators. The 3 arbitrators were Petrotrin's choice of the arbitrator, and who was appointed as an arbitrator was Justice Humphrey Stallmeyer, who was a former judge of Trinidad and Tobago and also a former judge of appeal of the Court of Appeal of Trinidad and Tobago. ANV's appointee choice of arbitrator was Lord David Hope, a retired judge of the Judicial Committee of the Privy Council, which is the final court of appeal for Trinidad and Tobago. Both ANV and Petrotrin agreed on the third arbitrator as the chairman of the panel. That person was Sir Dennis Byron, who was the former president of the Caribbean Court of Justice. So it would be seen quite readily that the panel of arbitrators was a very experienced, distinguished panel. The Court of Appeal of Trinidad and Tobago decides cases. They have in some cases, they can decide it finally. In other cases, the Privy Council is the final court for Trinidad and Tobago. The Caribbean Court of Justice is the final court of appeal for some of the countries of the Caribbean. So you would have seen that the judges who served on the Privy Council, who served on the Caribbean Court of Justice, who served on the Court of Appeal, were judges who were eminently qualified to do this job. And these were the judges who the parties agreed to determine this dispute. The panel of arbitrators, as I mentioned, were agreed to by both ANV and Petrotrin. But the parties also agreed in the contract, that is ANV and Petrotrin, in Article 36, that the decision of the arbitrators shall be final and binding, shall not be subject to review or appeal, and the parties agree to waive their right to any form of review, appeal, or recourse to any state court or other judicial authority insofar as such waiver may be validly made. It was therefore envisaged by both Petrotrin and ANV when this contract was signed that if there was a dispute, they would agree to have an arbitration and they would be bound by the decision given by the arbitrators chosen by them, and would therefore have confidence and regard that their findings were final and not subject to review or appeal, and delay and attempt to avoid the outcome. The panel consisted, as I said, of eminent judges of international reputation whose decisions ought to have much greater weight. The chairman of the panel of arbitrators was the former president of the Caribbean Court of Justice, which, as I said, is the final appellate court for some of the countries of the Caribbean. His judgments are reflected in the law reports of the Commonwealth, and he's recognized as an eminent international jurist by the legal profession, not only in the Commonwealth, but throughout the world. Similarly, the presence of Lord Hope, a former Privy Council judge, would also add to the weight of the findings made by the panel of arbitrators. Lord Hope is of the most accomplished judges of the Privy Council. He has given leading judgments in commercial law. It reported in most of the Commonwealth law reports, and he has had, since his retirement, experience in arbitration on the international scene. Last but not least, Justice Humphreys Tolmire, a former judge of the High Court and a former Justice of Appeal of the Court of Appeal of Trinidad and Tobago, who, apart from his recognized academic and judicial ability, is well familiar with the energy industry in Trinidad and Tobago and would also add great weight to the decision and findings made by the panel of arbitrators. I have decided to give the members of the public, the members of the media, some context in which this decision was made and in respect of the panel which made this decision. Let me now go to the statements of the leader of the opposition at the political meeting. On Sunday, the 10th of September 2017, during a UNC political meeting at Cuba, the leader of the opposition relied on a Petrotrin internal audit report, which, as I mentioned to you, was a preliminary report, dated 17 August 2017, which was marked private and confidential. It was not signed by the senior auditor, one of the alleged auditors. It was a preliminary, incomplete report, not a final report. To this day, we do not know, but can only imagine how it came to be in the hands of the opposition leader. The leader of the opposition, referring to the contents of that internal audit report, stated that ANB overstated its production of crude oil over a 6-month period, and that ANB was getting payment from Petrotrin for the supply of the so-called fake oil. She accused ANB and its owner, Mr. Hanif Baksh, of a conspiracy with Petrotrin officials to overstate the actual production by ANB of crude oil, and that ANB was being paid by Petrotrin for crude oil which Petrotrin did not receive. The leader of the opposition stated that ANB was selling this crude oil to Petrotrin as fake oil, which ANB never produced, and which oil was much more than ANB could have stored in its storage tanks. She accused ANB of committing fraudulent and criminal acts. The leader of the opposition then linked the Prime Minister of Trinidad and Tobago, Dr. Keith Rowley, with Mr. Baksh, the implication being that the Prime Minister was also involved in the alleged misconduct with ANB. She stated that ANB and its owner, Hanif Baksh, were financiers of the PNM, and that Mr. Baksh was a close friend of the Prime Minister. This political meeting, which the leader of the opposition addressed, was broadcasted live on several local radio and television stations, and it was also broadcasted on the World Wide Web via UNC's website and the Facebook page of the leader of the opposition. As a matter of fact, the video recording of this political meeting of the 10th of September 2017 remains posted on the opposition leader's Facebook page. Prior to the publication by the leader of the opposition of these allegations, Petrotrin had not taken any action on these unfounded allegations against ANB or Mr. Baksh. Petrotrin had not even informed Mr. Baksh of any such audit report or any such allegations which were being made against him or against ANB for allegedly overstating the supply of crude oil to Petrotrin. The conclusion drawn is that Petrotrin had not come to the view from its internal audit report that the leader of the opposition so quickly reached with no evidence. However, based on the statements made by the leader of the opposition, Petrotrin's then newly appointed chairman, Mr. Wilfred Espinay, on the 12th of September, just 2 days after that statement was made by the leader of the opposition, made a public statement which implicitly repeated the allegations made by the leader of the opposition against ANB. The leader of the opposition had called upon Petrotrin to take action against ANB. Petrotrin decided to commence an investigation into the allegations which the leader of the opposition made. The leader of the opposition was not satisfied with that. She took those allegations to the parliament, in that it formed the basis for the Prime Minister during question time in parliament to answer a question by the opposition whether he was a friend of Hanif Nazim Baksh, the owner of ANB. The Prime Minister confirmed that he was a friend of Mr. Baksh for a period of 7 years. The leader of the opposition, by taking this issue to the parliament in the context of what was happening at that time, was by her conduct and action further publishing the allegations she made against ANB and the Prime Minister in a statement of the 10th of September 2017. At several public meetings of the UNC, the allegations made against Mr. Baksh and the link of the allegations against Mr. Baksh to the Prime Minister were repeated by the leader of the opposition, which were carried live on the electronic media. These allegations of the supply by ANB of fake oil to Petrotrin, with the link of the allegations to the Prime Minister, were being pushed by the leader of the opposition as part of a political strategy. The leader of the opposition was doing this based on a preliminary audit report which Petrotrin itself had not acted upon, and which was a preliminary report, not a final report. And the leader decided to use this report to make these serious defamatory allegations against my client and the Prime Minister. These allegations continue to be published by the leader of the opposition at her political meetings, notwithstanding the several media conferences I called, in which I publicly called upon Petrotrin and the leader of the opposition to stop making these allegations. I call these conferences from time to time, and I showed at these media conferences for the public to see, for Petrotrin to see, for the government to see, for the opposition to see, that the facts show that ANV had the capacity to drill the oil. The Capsule field had the capacity to produce the quantity of oil. ANV had the investments and the machinery to drill the oil. ANV supplied the oil to Petrotrin. The pumps it had the capacity to pump the oil. And there was no evidence to show that oil was stolen by anyone. The leader of the opposition had to face, because the leader of the opposition did not stop making the allegations against ANV, and the lawyers for ANV decided to take action against the leader of the opposition. The leader of the opposition was given the opportunity by ANV and Mr. Hanif Baksh to withdraw the allegation made against ANV and Hanif Baksh, and to apologize and make an offer to pay damages for libel to his reputation and his company's reputation. It was pointed out to her that the allegations she made were false, and that she knew that they were false, and that they were causing serious damage to the reputation of both Mr. Baksh and ANV. ANV and Mr. Baksh filed a claim against her for damages for libel and claimed aggravated and punitive damages against her. The claim for damages for libel against the leader of the opposition by both ANV and Mr. Baksh was on the contention that the allegation she made against ANV and Mr. Baksh could not be supported by any evidence that she could have produced. Further, the leader of the opposition did not make inquiries to ascertain whether there were any grounds to support such allegation. As a result, we contended that the allegations made by her were made recklessly. That claim of ANV and Baksh against the leader of the opposition for damages for libel is pending in the High Court. But the leader of the opposition was not going to stop. Her whole motivation from the start was not only to use this issue, libeling my client, Mr. Baksh and ANV, but was to use this issue as a political issue, trying to score political points against the Prime Minister, and in the meantime, libeling my client and ANV. The leader of the opposition obviously saw this as raw politics and did not care whether the allegations were true or false. It seems as though it suited her politics to be able to go at the Prime Minister, and not caring whether, in doing so, she was damaging and possibly destroying the reputation of Mr. Baksh, the commercial reputation of his company, and causing his family great distress and suffering. This was not right. This was wrong. This was cheap politics. Petrotrin's refusal to have consultation with ANV. The issues which arise in this matter are not UNC issues. In my view, they are not UNC issues or PNM issues or issues of any political party. It involves national issues and the national interest. Apart from anything else, this issue involves every taxpayer of Trinidad and Tobago. It involves standards of conduct in public life. As one who served in public life, I can tell you there are times when the national interest trumps party political interest. There are times, therefore, when a person in public life must, in his or her actions, allow party political interest to be subservient to the national interest. Mr. Wilfred Espine relied on allegations made by the leader of the opposition. He rubber-stamped her allegations. He adopted them as if they were his own. And he decided to pursue the call of the leader of the opposition to investigate the allegations against ANB and Mr. Hanif Baksh. We had no problem with that. We wanted a fair investigation. Between September 2017 to November 2017, I wrote several letters. We wrote several letters to Petrotrin. They refused. I called several media conferences in which I informed the public of the baseless allegations being made by the leader of the opposition and Petrotrin against ANB, and called upon Petrotrin in these conferences to disregard the statements made by the leader of the opposition. I call upon Petrotrin to invite us, have consultation with us, show us the allegation. We will produce to you the evidence. Ask us any question. We will give you the answers. I told Petrotrin in letters and in the media conferences, there was no evidence which Petrotrin could have produced to prove that Petrotrin paid ANV for the supply of fake oil. Requests made by ANV in letters written on behalf of ANV and Mr. Baksh were for Petrotrin to hold consultation with us, for Petrotrin to engage with us, for Petrotrin to give ANV the opportunity to demonstrate that it was wrong, that Petrotrin was wrong, to demonstrate that Petrotrin was acting on baseless data and information which was contained in that alleged internal audit report. There was no evidence to support that. There was evidence from Petrotrin itself which negatived that. There was documentary evidence from departments of Petrotrin which negative all that was being alleged against ANV. Petrotrin kept promising that it would have consultation with ANV at the right time, but those promises were never materialized. Notwithstanding the request made on behalf of ANV for Petrotrin to have consultation with ANV, the then chairman of Petrotrin, Mr. Wilfred Espini, pursued the investigations on the basis of the allegations made by the leader of the opposition on which she relied on that incomplete audit report. And Mr. Espini knew from the information we supplied and from the records of Petrotrin that those allegations were inconsistent with Petrotrin's records. On the 25th of October 2017, attorneys at law for ANV wrote to Petrotrin stating that ANV observed a media report in which Petrotrin stated that it retained Kroll Consulting Canada to conduct a foreign examination into Petrotrin's audit report findings. ANV, as I told you, made attempts to get a copy of that report. Petrotrin said it was private and confidential. Petrotrin said it was going to rely on that report, but we could not see it, we could not answer it. On the 17th of November 2017, Petrotrin, without giving ANV an opportunity to make representations in respect of the Kroll report, published a media release in which it stated that the findings contained in the internal audit report were confirmed by Kroll Consulting Canada, also by Kaffney Klein and Associates. Petrotrin did not give ANV the opportunity to consult with Kaffney Klein on its proposed findings in its report. It was therefore a report without any input. ANV. Petrotrin took the position that Kroll and Klein reports were private and confidential, and although it was relying on the contents of those reports, ANV was not entitled to see those two private and confidential reports. I could tell you that the reports of Kroll and Klein relied on the data in the internal audit report. And if Kroll and Klein had the benefit of talking to us and sharing their concerns with us and giving all the evidence we had, which was produced at the arbitration, Kroll and Klein may not have misadvised Petrotrin. But it was Petrotrin's fault because Petrotrin had to conduct a full-scale inquiry, not a partial inquiry, not in respect of the internal audit report, because the internal audit report was based on certain data which didn't have all the relevant facts and didn't consider all the relevant facts. Next issue I want to tell you is how Petrotrin gave ANV 7 days to respond. The first time Petrotrin gave ANV an opportunity to respond to allegations it made was in the letter dated the 1st of December 2017, whereby Petrotrin stated that it reviewed the Kroll and Klein reports, which were private and confidential reports, and formed the view that it had reasonable grounds that ANV misconducted itself and was involved in a wrongful or fraudulent activity during the period April 2016 to July 2017. It then set out in that letter 13 issues and reasons for arriving at that opinion and invited ANV to provide its comments not later than 7 days of that letter. So while Petrotrin had months in which to settle that letter, Petrotrin is saying that, boy, we agree you're guilty, but you only have 7 days to respond. So doing the best it could have done in that short period of time, 7 days, ANV answered the allegation. It was clear from the contents of Petrotrin's letter of the 1st of December 2017 that Petrotrin had made up its mind to terminate the contract before it sent that letter, but it was only going through the motion giving ANV a cosmetic period of 7 days to respond to answer the allegation. Despite this, Petrotrin insisted, despite all of this, all of the representation we made, all of the offer we made to show you had no evidence, Petrotrin insisted on ejecting ANV from the field on the grounds that it had lawfully terminated the contract and that it resisted ANV attempts in the courts to obtain an injunction to stay, for ANV to stay in the field pending the resolution of the dispute. The arbitration nevertheless went ahead and it has now been completed and ANV has now been vindicated. Consequently, the defamatory allegations made against the Prime Minister being connected to this alleged conduct of ANV can also have been vindicated. But that is what I am saying, and that is what other people may say who have read the judgment. The question is, are taxpayers entitled to see the judgment? Are taxpayers entitled to see how these eminent judges dealt with those allegations? Are taxpayers entitled to see what comments, if any, were made by the arbitrators in relation to the case of Petrotrin and the case of ANV? And I'll come to that in a short while. The leader of the opposition, however, following publication of some matters about this arbitration and its result on the newspapers, at a public meeting on Monday, the 14th of June, instead of making an apology in the light of the publication in the media that ANV won its arbitration in respect of the termination of the contract, which termination she knew was based on the allegation she made at a public meeting in 2017. She again referred to the 100 million fake oil. She tried in her statements to give the impression that the arbitration was won by ANV on a technicality because the Attorney General did not do a proper case in not supplying all of the relevant evidence. This is not totally untrue. It is a misrepresentation of what the leader of the opposition should know of the function of the Office of the Attorney General. She served as Attorney General of Trinidad and Tobago for a short period of time. The Attorney General was not responsible for the evidence provided in this arbitration. The Attorney General represents a state. Petrotrin was not under the jurisdiction of the Office of the Attorney General. Petrotrin had its own counsel, and the chairman of Petrotrin was answerable to the board of directors of Petrotrin. Petrotrin retained its own lawyers. The Attorney General office would have had nothing to do, the Attorney General or the Office of the Attorney General, from my experience, would have had nothing to do with this case. This was a case in which Petrotrin retained, and is on record, private attorneys at law. The attorneys at law which Petrotrin retained included senior counsel Deborah Peep and Mr. Ravi Hafiz Dun, and a private firm of instructing attorneys at law. So the Office of the Attorney General did not have conduct of this case on behalf of Petrotrin. The allegation, therefore, that the Attorney General was responsible for not calling the relevant evidence and therefore Petrotrin lost the case is totally false. It is curious and startling that a person who served as Attorney General of Trinidad and Tobago could go publicly on behalf of a party and to say to the country that in a case between Petrotrin and ANV and Petrotrin, that the Attorney General had jurisdiction over that case. When law students know that Petrotrin is governed by a board of directors, and the board of directors is responsible for those affairs of the company. The Attorney General, as I said, had nothing to do with this case. This was a case, as I said, had its own lawyers. Petrotrin was well represented. It had every opportunity to adduce all its evidence before the arbitrators. Petrotrin, throughout the arbitration proceedings, attempted to take technical points. My conclusion on that is because it really didn't have evidence to answer A&B's case. The reality is that the case was determined by a highly respected international panel of arbitrators chosen by both A&B and Petrotrin. So, Madam Leader of the Opposition, understand that. You were wrong. You caused serious harm to my client, to A&B, and as a politician, you owe a duty to apologize. Again, the Leader of the Opposition at the political meeting on Monday, the 14th of June, 2021, demonstrated that she was really interested in her party political interests and her own interests in trying to give the impression to the public that the Attorney General, as a member of the cabinet, was involved in the arbitration, and that the Attorney General did not call the relevant evidence which caused Petrotrin to lose the case. The cabinet was not part of this case. The cabinet had nothing to do with this case. As Attorney General, I know that when state companies have litigation in court, the Attorney General doesn't interfere in a case. The cabinet doesn't interfere in those cases. So the Leader of the Opposition, who served as Attorney General and therefore would have known that the chairman of the board of directors and the board of itself would have had the responsibility for this case. The chairman and the board had a duty to see that there was evidence to support the allegation. The board had a duty to ensure that it made the chairman of the board accountable to the board, to ensure that the decision to terminate the contract was properly made, that it was made on the basis of evidence to show that there was no fake oil, not suspicion, evidence to show. That was not a function of the Attorney General of Trinidad and Tobago. These foreign audit firms, Kroll and Klein, were not retained by the Attorney General. They were retained by Petrotrin, and they were retained on the advice of Petrotrin's senior counsel and lawyers. Those were the instructions of Petrotrin, not the Attorney General. I'm not holding any brief for the Attorney General, but I have a duty as a previous Attorney General and one who knows the working of this and the law to tell the country that this is wrong. It is therefore wrong for the Leader of the Opposition to make it appear to the public that the Prime Minister or the Attorney General had anything to do with the conduct of Petrotrin's case before the arbitrators. The leader of the opposition also by her comments has shown public disrespect to the arbitrators to allege or to insinuate that these eminent judges as arbitrators could have made a decision based on influence by politicians. I want to give the public an idea of how an arbitration works. The procedure employed by arbitrators to determine a dispute and this dispute is the same kind of procedure which is employed by a High Court judge in the High Court. ANV, in support of its case, had to file what is called a statement of case. In that statement of case, it had to give all its material facts on which it relied upon and all the relevant facts that Petrotrin wrongfully terminated the contract. Petrotrin, in answer to that statement of case, had to file a defense. Petrotrin had to answer all the allegations made by ANV in its statement of case. And it had to stay in that defense why it is saying that it was right to terminate the contract. It had to produce a pleading to say it had evidence to support it. ANV would have had a chance to put in a reply to the defense of Petrotrin if any new matters were raised, and Petrotrin would have had a chance to put in what is called a rejoinder if any new matters was raised in the reply. But that was not the end of the matter. More papers had to be filed. ANV had to file witness statements to support its case. The witnesses had to give evidence on oath. And Petrotrin had to file witness statements to support its case. But that is not the end. The arbitrators in this case didn't decide the case on witness statements without seeing all these witnesses. There was a virtual hearing of this arbitration, which lasted 14 days. It started on the 23rd of November. It went to the 27th of November, then the 30th of November, then went to the 1st, to the 5th, and the 16th to the 18th of December, 2020. At these hearings, witnesses were cross-examined. The witnesses for ANV were cross-examined by Ms. Deborah Peak and her junior lawyer. The lawyers for ANV cross-examined Petrotrin witnesses. Then there were submissions. Both sides had the opportunity of making submissions. It was agreed for submissions to be made in writing. There were extensive submissions made. And the arbitrators took from December 2020 to June, almost 6 months, to arrive at their decision, reviewing, reading, analyzing, assessing, and deciding. In conclusion, I am saying the members of the public, therefore, have the right to know the contents of the judgment given by the arbitrators in this matter, because this was an arbitration in which the facts and circumstances which led to the arbitration show that politics influenced the investigation, which was launched by Petrotrin against ANV and Mr. Bash. As I pointed out, the opposition leader challenged Petrotrin to do this investigation and called upon it to do the investigation. Members of the public therefore have a right to know of the assessment made by the arbitrators, and they have a right to know of the evidence led at the arbitration. For members of the public and the media to make their judgment as to whether there was vindication or not of the allegations made by the public by both the leader of the opposition and the newly appointed chairman of Petrotrin. The need for members of the public to know these matters is heightened by the fact that millions of taxpayers' dollars were spent by Petrotrin in order to pursue the allegations made by the leader of the opposition. Members of the public, therefore, are entitled to know whether it was justifiable for Petrotrin to pursue these allegations in the light of the evidence which Petrotrin presented to the arbitrators, and in the light of the assessment made of the evidence and the decision given by the arbitrators. It is also important for the public to know whether government would allow or permit taxpayers' monies, more taxpayers' money, to spend in Petrotrin further litigating the issues in this matter. Although the government does not make decisions for the board of directors, the company is owned by Trinidad and Tobago, the shareholders, the corporation soul. And therefore, the corporation soul is responsible to be able to determine whether taxpayers' monies could be used to further litigate these issues. If the issues are further litigated, I would have no complaints. It's better for lawyers. It's more fees. But in the public interest, I am saying that this would be a further waste of taxpayers' monies. I wish to make it clear that quite apart from all these considerations of taxpayers' monies, I have a duty to say that where a leader of the opposition of this country has made serious allegations of corruption against the holder of the office of Prime Minister, and there is a determination of the allegations or determination of the allegations which supported the allegations made against the Prime Minister, the national interest requires for members of the public to assess for themselves and to know the assessment made by those arbitrators, not only in relation to A&V matter, but for the purpose of whether there was any truth in the allegations made by the leader of the opposition. As I said, this is not a party political issue. This is a national issue. It does not matter whether the Prime Minister is a member of the PNM or a member of the UNC or some other party or some other political party. We are talking about the office holder of the Prime Minister of Trinidad and Tobago. And in that context, I believe that the public interest has to be properly served in this matter in the light of the history of this matter and in the light of what has happened at the arbitration level. Let it be clear, no question of sub judice arises in a civil matter. The arbitrators have already made a decision, and therefore no question of sub judice can arise. But in any event, this issue was tested in a case in which the media in London made comments and criticisms about a civil matter, and there was an attempt to raise the sub judice point as a contempt of court against the newspaper, the Sunday Times. So the case is the Sunday Times versus the Attorney General of England. And in that case, the House of Lords, who are the same judges who sit in the Privy Council and the Supreme Court of London, which is now the equivalent of the Supreme Court of the United Kingdom, decided that a judge in a civil case cannot be influenced by what members of the public or say. In other words, it said that if a judge with the oath he has taken could be influenced by what the press write or what the public say or what people say outside of the court, that person is not fit to be a judge. So I have decided in my duty, which I've had over the years in doing some public legal education, and in particular in the duty in this case, because it is one of the cases in my career as a lawyer for over 50 years I found very puzzling and startling. I could not understand, and I still cannot understand, how a state company, without any evidence to implicate a man and a company on fraud based on pure suspicions, could have gone so far to break the company, to destroy the company, to destroy and damage the lives of people in the company. I cannot understand that. And to me, nothing that happens now could totally compensate for that injustice. But the only consolation I have that this would not happen again, and I am doing this in order to send a signal that governments should not allow state companies and state corporations and state bodies to be rogue bodies. Some machinery has to happen for some of these state companies to be accountable, and that when they do wrong like this, it should not be left to the individual to go against the directors or anyone. There should be some recourse, but this is the worst that I've seen in my 50 years as a lawyer, and during which time I had some service in the politics. Thank you very much. I'm prepared to answer any question, and I'll ask some of my juniors to answer some of them. Thank you very much for coming.
Ms. Maharaj?
Yes.
Can you say how much taxpayers' money will now have to be paid in damages arising out of this matter?
Determined as yet by the arbitrators. That would be another hearing, unless the parties can settle the issue of damages. Obviously, what happens sometimes in these cases, both sides get together and try to settle the issue instead of having a further hearing and a further assessment. So, but the damages issue has not been sorted out. The liability issue has been sorted out, but not the damages issue. But the cost would be tremendous, because there were on behalf of A and B, there were many foreign experts, and on behalf of Petrotrin, there was the evidence of Kroll and Klein. I think we had how many experts?
We had 4 experts.
We had 4. How many foreign experts?
3 foreign.
We had 3 foreign experts, and you would remember that this matter lasted over a period from 2017 to about 2019, and there were a lot of procedural hearings and paper. So what the public normally see is probably the beginning or the end, but there's a lot of work done. A lot of Petrotrin would have taken a lot of technical points. We may have taken points which Petrotrin considered to be technical, and there were arguments, there were rulings. So legal fees in these matters can be, you're talking about millions of dollars. Legal fees and arbitration expenses, because remember we had to pay the arbitrators, both sides had to pay the arbitrator. That is why it is important for the public to know. Any other question? Well, members of the media, I try my best to make this as simple as possible. I hope that I met that threshold and you were able to understand the issues. So if there are no more questions.
Hello? Hi, Just for clarity purposes, so the amount that was awarded that is supposed to be paid, if not coming from the taxpayers, then who would be paying these damages?
Well, if Petrotrin has to pay the damages, it's ultimately, in my view, taxpayers' monies, because monies which could have been used by Petrotrin for other purposes or by the government for other purposes.
Mr. Maharaj, would have this decision taken by Petrotrin, which the arbitration panel would have overturned, did that decision to cancel the contract between the parties cripple the company's business? This asking because basically I no doubt that would affect any damages or assessment of damages later on.
Well, Petrotrin did not only terminate this contract, my client had another contract. And that contract was also terminated, and this termination had an effect on the termination of that contract. So it really made a big dent in the operation of the company. And remember, we're living in a small society with these serious allegations made against both Mr. Baksh and the company. You will appreciate the kind of difficulties the company would have had in operating. In this case, remember the damages, if the damages have to be assessed by a tribunal, the damages would include, business that the company would have lost because of this. But I want to say that notwithstanding whatever has happened in this case, I am committed that if the government and Petrotrin at any time ready to try and resolve the issue of damages without prejudice, I'm prepared to have discussions with them.
Before you close, we should make a point about, he has no objection to the award of the legal department.
Oh, yes. I want to put on record that ANV does not have any objection if the government agrees for the judgment given in by the arbitrators to be laid in Parliament and to be made public. As a matter of fact, we take the position that that is what has to happen in this case. And the second thing I want to say, in case that I will provide to members of the media that I have the addresses for a copy of what I said today. And if any members of the media or anyone is listening and they want a copy of what I said today, if they email my office and give me your details, I will get my personal assistant to send a statement to you. Thank you very much, members of the media. Any other question? Okay, well, so we can end the conference. Is that okay? Yeah, okay. Thanks a lot.